You'll see here that if the defendant is involved in an offense that is a violation of Chapter 117, and during the commission of this offense there's an actual sexual act that has occurred or some sort of sexual contact, that defendant is going to have a base offense level of 24. Alternatively, if you have a defendant involved in an offense that is also a violation of Chapter 117, but there's no sexual act or sexual contact that occurred, your offense level in this case is going to be a 21. And what you'll find is that this distinguishes between cases where the sexual contact actually occurred and cases where it didn't. So most of your level 21 cases are going to be the government sting cases where the undercover officer is posing as a child over the internet. I think those are the kinds of cases we see the most there. And then 18 is the other alternative offense level for any other cases that don't fall under 21 or 24. Similarly, we have a specific offense characteristic at 2A3.4, which is the abuse of sexual contact guideline, and this provides for a 3-level increase if the offense involved a violation of Chapter 117. Again, those types of offenses that Congress is concerned about. Now, Krista, can you walk us through some of the other changes that we'll find in regards to sexual offenses? Sure.
One of the biggest changes you will see in this amendment package is actually the implementation of a new guideline, Guideline 4B1.5, which deals with the directive that Pam just mentioned, which is the pattern of activity of sexual abuse or exploitation of minors. Now, 4B1.5 is divided into two subsections, subsection A and subsection B, and they work a little bit differently. We're going to take one at a time, and we're going to start with subsection A. Now, under 4B1.5A for repeat and dangerous sex offenders against minors, the first requirement is that the instant offense of conviction is a sex crime against a minor under Chapter 109A, Chapter 110, which does not include trafficking or possession of child pornography, or Chapter 117. That's the first requirement. The second requirement for application of subsection A is this defendant must also have one prior conviction for a sex crime against a minor. And this guideline operates, this first part of the guideline increases not only the offense level, but also increases the criminal history category as well. Looking at the offense level will be the greater of the offense level determined under Chapters 2 and 3. So you would go to, for example, 2A3.2, apply that guideline, any applicable Chapter 3 adjustments. You take that and you compare that to an offense level that's determined under a table that we have here at 4B1.5A, which is similar to career offender. As you can see, it's pegged to the statutory maximums of the instant offense of conviction. So the offense level could be raised as high as 37 in some instances. So whichever is the greater, either what this table directs the offense level to be, or the offense level that was calculated under Chapters 2 and 3 is the offense level to be used for these defendants who qualify under this guideline. Now, the second part of application for this subsection A under 4B1.5 is the criminal history category. And when you're dealing with the criminal history category, you're going to take the greater of either the criminal history category that was determined under Chapter 4, Part A, or criminal history category 5. So unless the defendant's criminal history category was a category 6, the criminal history category will automatically be raised to a criminal history category 5. Now, subsection B of 4B1.5 operates differently, but the requirements are that the instant offense of conviction, again, is a sex crime against a minor. Neither 4B1.1, the career offender guideline, nor the first subsection of this guideline apply, and the defendant engaged in a pattern of activity involving prohibited sexual conduct. Now, the most important thing for application of this subsection is the definition of pattern of activity. And what this means is that the defendant engaged in prohibited sexual conduct on at least 2 separate occasions, and at least 2 minors were the victims of the pattern of activity on those separate occasions. So repeated acts against the same minor would not trigger that increase. You must have 2 different minors on 2 different occasions that were the subject of sexual abuse. Now, this operates differently than subsection A, because we are only going to be increasing the offense level if the defendant qualifies under this subsection. It is a 5-level increase in the offense level that is determined under Chapters 2 and 3. And the minimum floor offense level that's provided in this subsection is a level 22. The criminal history category that was calculated under Chapter 4, Part A stays the same. So that is a quick look at the 2 subsections of this new guideline for repeat and dangerous sex offenders as found under 4B1.5. There is one more part to this amendment, and that is the resolution of a circuit conflict dealing with the grouping of trafficking, receipt, and possession of child pornography. You will see now that guidelines 2G2.2 and 2G2.4 are listed as groupable under Rule D. That is, they're listed for grouping at 3D 1.2D. Now, this eliminates the victim determination that generally is made for grouping under Rules A or B under Guideline 3D 1.2. Under 3D 1.2D, that's not required. What also results from listing these offenses as groupable under this subsection D under 3D 1.2 is it ensures use of expanded relevant conduct, which is found at 1B1.3A2, which means that, for example, if a defendant is convicted of one count of trafficking in child pornography that lists one picture, application of the trafficking guideline is not limited to that one picture because of expanded relevant conduct. The court can look at conduct that is the same course of conduct or common scheme or plan as the offense of conviction. So even though the count of conviction may only cite one picture, the other 1,000 pictures that are listed or kept on the defendant's computer can be used in the calculation of the trafficking and child pornography guideline to more accurately represent the defendant's actual behavior. Lauren?
Okay, thanks, Krista. But to close out this section, Pam, is there anything else that we really need to know with regard to the changes to the sexual abuse guideline?
Just that the Commission has taken a very targeted approach in dealing with Congress's directive in this area. Congress was concerned with those who prey against minors, and that's who our guidelines target, those people who have convictions or other kinds of misconduct for that B prong of pattern activity against minors.
So against minors is key.
Against minors is key.
Okay, okay, great. Now we've also had changes to the immigration guideline, and Rachel's going to take care of that.
That's right. We have had changes regarding immigration offenses, and specifically the illegal reentry guideline at 2L1.2 has been changed. Now, this was done in response to a number of concerns raised by judges and probation officers and attorneys, particularly in the southwestern border states, because they do get a lot of these illegal reentry cases. And the concern was expressed because the 16-level enhancement for an aggravated felony, it appeared, was being applied in cases without any regard for the seriousness of the prior felony. And it was felt by the courts and the probation officers, and specifically this area of the country, that that was not that was unfair, and that it was resulting in disparate sentences among these types of defenders. And so they were remedying that by departing downward to achieve a sentence that is more realistic for what the defendant should be sentenced for based on the seriousness of that prior felony. So in order to remedy that, what the Commission has presented is graduated sanctions, so that we have different increases depending on the seriousness of the prior felony. You're going to get a 4, an 8, a 12, or a 16-level increase depending on the prior felony. So let's just look at these increases. A 16-level increase, we want you to look at certain types of offenses, specifically drug trafficking offenses, felony offenses of course, for which the court imposed a sentence that exceeded 13 months. Certain types of other offenses, crimes of violence, firearms offenses, child pornography offenses, national security or terrorism offenses, human trafficking, and any alien smuggling for profit offenses are also going to receive this 16-level increase. Moving on to the other increases. 12-level increase will apply for any felony drug trafficking offense where the sentence imposed was 13 months or less. So again, we're looking at felony drug trafficking offenses, but the difference here between the 12 and the 16-level increase is the time imposed on that sentence. Now you're going to get an 8-level increase, or the defendant's going to get an 8-level increase for any other aggravated felony conviction. And the application notes once again refer you back to the statute for definition of what is an aggravated felony. And then a 4-level increase for any other felony that doesn't fall into the 8, 12, or 16 level, or 3 or more misdemeanor convictions for crimes of violence or drug trafficking, which were not related to each other.
Now, Rachel, you mentioned that some courts were departing based on the seriousness of the aggravated felony. Wasn't that the subject of a circuit conflict?
It was the subject of a circuit conflict, and one of the other things that the Commission did when amending the 2L1.2 guideline was resolve that circuit conflict by deleting that language. And it is through the implementation of this tiered or graduated sanctioning that there should no longer be a need for these courts departing downward in the cases of a 16-level bump given to a defendant regardless of the seriousness of the prior felony. So.
Okay, great, thanks. Now we've covered the major topics that will most likely impact the majority of defendants sentenced under the guidelines. Still, there are quite a few other amendments that we're going to go over. And Pam, why don't you start us off with, there are some changes in the areas of stipulations, I think.
Yes, Lauren. There was a circuit conflict dealing with the definition of the word stipulation in Guideline 1B1.2. You know, the guideline starts as an offense of conviction system. You use the applicable guideline that goes with your offense of conviction, except if the defendant stipulates to a more serious offense. And that's where the circuit conflict occurred. What happens if the defendant during the plea colloquy makes an admission that sounds like he's admitting to a more serious offense? Some courts had said that was a stipulation and sentencing the defendant to that, using that higher guideline to sentence the defendant. What the Commission has clarified is that a stipulation must be made pursuant to a plea agreement. This will eliminate the problem of surprise, especially surprise to the defendant as to which guideline he'll be sentenced under. So that's how the Commission resolved that conflict.
Okay, great. Now I understand there was also an amendment that has to do with aggravated assault. Alan?
Yes, Lauren. There had been a circuit conflict had arisen over the fact when someone uses a non-inherently dangerous weapon, such as a car or a chair, whether the use of that weapon can be used as, number one, a basis for that individual to be sentenced under the aggravated assault guideline at 2A2.2 as opposed to 2A2.3, and then also whether that factor, the use of the non-inherently dangerous weapon, could be used in applying the specific offense characteristic in 2A2.2 for the use of a deadly weapon. Some circuits had stated that you could use both factors or use that factor to, number one, raise the sentence to the 2A2.2 guideline, and then also for the specific offense characteristic. Whereas two circuits had stated that that was impermissible double counting to use that same factor twice. What the Commission has done is it's clarified within 2A2.2 that the use of a non-inherently dangerous weapon can be used as the basis for, number one, getting the individual up to the 2A2.2 guideline, the aggravated assault guideline, and then also to be used in conjunction with the specific offense characteristic at 2A2.2 B2 for the use of a deadly weapon.
Okay, great. Now there's also another one involving mitigating role, and I think you were going to take that?
Yes, correct, Lauren. The Commission also resolved another circuit conflict over mitigating role, and this may apply to mostly drug defendants, but will also apply to other type of defendants. Essentially, what this circuit split was over was, in some circuits, in order to be eligible for a 3B1.2 adjustment, there was differing standards depending on the person's relevant conduct. Essentially, this circuit split is over in cases where a defendant who has a limited role function and is only held responsible in a conspiracy for the actual involvement that he actually personally did. In those situations, some circuits had said that that person is precluded from getting an adjustment under 3B1.2 mitigating role. Other circuits had stated that you could get that adjustment even if the defendant's own personal conduct is the only thing that's driving the sentence. What the Commission has done in an application note is with an application note decided that an individual with limited role function and who's only being held accountable for his own personal conduct is still eligible for a 3B1.2 adjustment. Essentially what this means is it doesn't open the floodgates that every single person who fits that definition will automatically get the 3B 1.2 adjustment. But what it does do, it allows the court to consider the fact that the individual had a limited role function, and additionally his personal involvement was the only thing driving the sentence, can be eligible for that reduction. In addition, an example of this is mostly going to apply to drug couriers. For example, a drug courier in a conspiracy in which other people are working in that conspiracy, in the drug conspiracy, if that defendant, the drug courier, is only held accountable for his personal involvement in the drugs, in taking the drugs from point A to point B, and nothing else, and has a limited role function, that individual now throughout the country is eligible to receive a 3B 1.2 mitigating role reduction. So this may help some defendants in certain circuits.
Okay, great. Now there are still a few other amendments that need to be gone over, and for that we are going to go to Krista and Rachel.
Thank you, Lauren. Those of you who have been dealing with firearms offenses, and specifically the guidelines 2K2.1 and 2K1.3, I'm sure are aware that the defendant's base offense level can be increased at these two guidelines, either for prior felony convictions that the defendant has or the status of the defendant being a prohibited person. Now, there was a circuit conflict that arose around what time frame do you look at to determine the prior felony convictions and whether or not the defendant was a prohibited person. The time frame being, or the circuit split being, some circuits were looking at the time the offense was committed, other circuits were looking up all the way until the time of sentencing. So the Commission has gone in and resolved this circuit conflict so that the prohibited person status must have been attained prior to the completion of the relevant conduct for the instant offense. Parallel to that, the prior felony convictions, if any, must have been sustained prior to the completion of the relevant conduct for the instant offense. So the Commission has gone with the time frame of the time at which the offense was committed. So your earliest date of relevant conduct is what you're going to look at to determine whether or not you're going to increase the defendant's base offense level on the status of prohibited person or because of prior felony convictions.
Right. Now, in the beginning of our program, Lauren mentioned that perhaps 40 to 60% of all cases were going to be impacted by basically the top 5 amendments that we just went through: the economic crimes package, the drug amendments, the sex crimes amendments, the money laundering amendments, and the immigration amendments. We have talked a little bit about the circuit conflicts, the additional ones that have been resolved, and still there are other amendments and these lesser used guidelines, but we want to quickly review those before we get to some of your faxes. The counterfeiting guideline at 2B5.1, we've added a specific offense characteristic that increases by 2 for offenses involving manufacture. Human trafficking, this was an emergency amendment directive. It was first implemented on May 1st of 2001. Upward departure language was placed in guidelines 2G1.1, 2G2.1, and 2H4.1. 2H4.2 is a new guideline. The stalking guideline at 2A6.2, there the base offense level was increased from 14 to 18. Guideline 2C1.3 was consolidated basically with guideline 2C1.4, so you've seen a few instances where we have had consolidation of guidelines. So 2C1.4 no longer exists. You go to 2C1.3 for those offenses. Tax privacy is a new offense. There you will go to guideline 2H3.1 for offenses involving that issue. And the Commission, I guess sad to say, was sort of ahead of the ball game by increasing penalties for nuclear, biological, and chemical weapons. So there was increases in 2M5.1, 5.2, and 2M6.1. So that wraps up our other amendments that we haven't previously mentioned. Lauren?
Okay, thanks, Krista. We now have about 10 minutes remaining, and in that remaining time, we're going to try to hit some of the questions that you're asking us by fax, and the number's on the screen, so please feel free to drop us a line. But first, to kick it all off, Pam, I want to ask you, what does the Commission have on its agenda for 2002?
Well, Lauren, the Commission has set a much more limited agenda this year. There are 3 main areas of interest. The Commission is continuing its study, its 15-year study of the guidelines. Next year will be our 50th anniversary, and we're completing a comprehensive review of the guidelines and the impact of the guidelines on the criminal justice system and how it has met the purposes of sentencing. The Commission has also decided to look at the drug guidelines. This will be a multi-year project, but this first year, we're specifically looking at cocaine sentencing policy. As you recall, back in 1995, the Commission amended the guidelines to equalize the penalties between crack and powder cocaine. Those statutory provisions remained, but the Commission made a change to the guidelines. The Commission is once again looking at this issue, and we aren't exactly sure what will happen, but the Commission is evaluating its cocaine sentencing policy. The third major area is criminal history. This again is a multi-year project, but this year the Commission is looking at how our criminal history guidelines impact our first-time offenders. That's one of the issues that the Commission is considering. Again, this may take some time before we see actual amendments, but that's what we're studying this year. And of course, we will respond to any kind of congressional directives, and we have indeed formed a team to look at some of the recent terrorism amendments. So we have a team looking at those issues and a few others.
Okay, and they're looking at those issues right now, then that's the
That's
plan for now.
That's what we're looking at right now.
Okay, great. And if I'm not mistaken, isn't this the first time that there aren't any directives remaining from Congress?
That's right. The Commission worked hard those first 2 years and completed all those pending congressional directives. So right now, we don't have any.
Okay. But that's probably not going to last for long. So
it may not.
Okay.
We'll see.
All right. Now, Alan, there's another question here that I think we can direct to you. It's in the money laundering category. It says the defendant here is convicted of money laundering. However, under Section 1B 1.3 A1A of relevant conduct, the defendant is accountable for the drug trafficking offense from which the laundered funds were derived. The defendant managed over 5 participants in connection with the drug trafficking offense. Now, when applying the guidelines for his conviction of money laundering, will the defendant receive an increase under the Section 3B 1.1 aggravating rule?
Okay, Lauren, that issue involves basically 2 questions in one. Number one, when dealing with Chapter 3 adjustments, you're going to have to look to whatever count of conviction you're working on. So if you're working on the money laundering count of conviction, which is what the question is asking, then no, you would not apply that 3B 1.1 adjustment for aggravating role, because the aggravating role that the defendant took applied more to the drug guidelines at 2D 1.1. You calculate your 2D 1.1 sentence. At that stage, you would use your 3B 1.1. But when dealing with money laundering, when the money laundering offenses, all Chapter 3 adjustments go just to the role in the money laundering offenses. So.
Okay, great. Now, Pam, there's another question here under the sexual abuse guidelines. Let me see where I have it. Under the Section 4B 1.5 guideline, to qualify for the A prong, can a prior sex offense of conviction against a minor be a tribal conviction, or could it be a juvenile conviction? I guess what type of conviction works here?
Right. The Commission, in implementing this guideline, carefully defined the types of prior convictions that would trigger this enhancement. They're defined at 18 U.S.C. 2426 B1A. A specific statute lists those types of prior convictions. Those types of prior convictions do not include tribal convictions or juvenile adjudications. So just please be careful and read that statute to see what the qualifying convictions are.
Okay, so they really have to read the statute and just make sure that everything's covered or not covered, as the case might be.
That's right, Lauren.
Okay. Now there is another, I think, well, we almost have time for one more question. Let's see, under, again, this is a sex abuse question for the guideline. In order for a defendant to qualify for the pattern of activity increase under Section 4B 1.5b, is a conviction required for prior sexual conduct?
Under 4B 1.5b, a conviction is not required. The pattern of activity can be any kind of misconduct that the court finds by preponderance of evidence did indeed occur. we do not require a conviction for that prong of the enhancement.
Okay. Okay, great. Now I know there were still a couple of faxes here that we did not have a chance to get to, but I'm sure, like we do with the helpline, Pam, you're going to be able to get the Office of Education Sentencing Practice can get back to some of these folks with answers to their questions and concerns. Okay. And since we are getting ready to wrap up the program this afternoon, Pam, as the Director of the Office of Education Sentencing Practice, are there any final thoughts that you might have?
As you can tell from the program, there have been a great deal of changes to the guidelines this year, and we're available here to help you to respond to these application issues. Please call the Sentencing Commission's helpline at 202-502-4545. We also urge you to look at our website, www.ussc.gov. There you can find lots of resources that can help you in understanding these new amendments. You will find our amendment highlights and other resources. So please call us if you have a question, and we will certainly do our best to help you.
Okay. And with that, you are updating the most frequently asked questions about the amendments and putting together most frequently asked questions about the amendments, right? Okay.
Right. We'll be putting out some most frequently asked questions about the amendments. During the training this year, we've had lots of questions. We'll be making that available to users of the guidelines.
Okay. Okay, great. And just as a final note, there are direct links from the DCN site on the FJC's FJTN page under this program, 2001 Amendments, that go directly to the Sentencing Commission's website. So you can either go there directly or go there through the DCN site, whichever you prefer. And with that, I'd like to thank you all very much for participating this afternoon. Like I said, if we didn't get a chance to answer your question, I hope we answered many of them that you might have had surrounding the 2001 amendments, but if we didn't get a chance to, I know, and as Pam said, the Sentencing Commission will be more than happy to get back to you with an answer to those questions. And I'd really like to thank our panelists here today, both Pam and Alan. Thank you very much for participating, as well as Krista and Rachel. And the entire Commission for helping us put together the program here this afternoon. Please remember to fax in your participant rosters and your program evaluations. You have no idea how important they really are to us in determining future programming. So we really do take a look at those, so we really would appreciate if you send those back in, particularly if you are getting CLE credit or are interested in receiving CLE credit. You will not receive CLE credit if you do not turn those things back in with the proper boxes marked and checked and all that sort of stuff. So be sure to do that. Finally, just one last thing. Remember, if you would like the slides for today's broadcast, they will be available on the DCN after November 19th. And with that, that is all that I have for this afternoon. So thank you very much for participating again, and have a wonderful day.